Grab your friends, wear your florals. We're going to court. Taylor Swift and Hugh Jackman are about to be deposed. And there are still so many questions about this mystery subpoena and this sham lawsuit. I have the Ask Two lawyers on today because I'm going to ask them a lot of questions about this because they understand the law way better than we do, even though some of you like to fight with me in the comments online. But I hope you're ready for it. Let's dive in. You're listening to No Filter with Zach Peter, your go-to source for all the latest pop culture and reality TV tea, served fresh all week long. Now, let's dive in. What's going on, guys? Welcome on in, welcome on in, welcome on in. I hope you are ready. Today's going to be a fun Q&A. I have a lot of questions about Stephanie Jones, Jones Work PR, privacy laws when it comes to text messages, all that good stuff about the subpoena and the Van Zandt seemingly shell company. I have questions about that as well. I was excited to have Josh from the Daily Mail, senior reporter for the Daily Mail, who really investigated this story and broke it last week, or covered it last week rather, and had a very enlightening conversation with him on Monday. And so to follow up on that, I have the Ask Two Lawyers guys on. But very quickly, I did want to remind everybody that we do have today is the final day. If you're going to get tickets for the Zactivated tour, today is the final day to lock in early bird pricing. April 23rd, Wednesday, April 23rd. You have until end of day today to lock in early bird pricing before the prices go up tomorrow on Thursday morning. So you can head on over to nofilterlive.com. I'm coming to Dallas, Phoenix, Philly, Toronto, Brooklyn, Chicago, Seattle, Los Angeles, and there's so much that, I mean, there are several announcements that'll be coming over the next several weeks, but there's so many exciting guests and just like tidbits that are going to be incorporated into this tour. And another element that I just started having meetings about that is going to be even exciting after the tour. So just get ready, grab your friends, wear your florals, get your tickets, go to nofilterlive.com, and I'll see you there. I'll see you in Dallas, Phoenix, Philly, Toronto, Brooklyn, Chicago, Seattle, or Los Angeles. I saw some of you have bought tickets to multiple cities. So if you have, be sure to drop a comment below. Let me know where you'll be, what city I'll be seeing you in, what tickets you got. Let me know. We see you in Phoenix. Shans is going to see us in Phoenix. I love it. Yasmin says, can't wait for Toronto. Cassie's coming to Chicago. Chicago's going to be the big one. Yanni says, grab your friends, bring your subpoenas. Well, actually, I believe during the summer, July and August is when all of the fact discovery is going to be coming together because it's due, I believe, by August 14th. I have questions about that, and I'm going to ask Keith and Stuart about it. But let's welcome them. Keith Davidson, Stuart Albertson from Ask Two Lawyers. Hi, guys. Welcome back to the show.
Hey, Zach, thanks for having us on, and congratulations on the Zactivated tour. That sounds really exciting, although I looked through the cities and I did not see San Diego.
I know. Well, you have Los Angeles.
That's true. We'll fly up. Well, you know what? Stuart and I will fly up to Los Angeles.
It's like a 2-hour drive. It's like a 90-minute drive.
Yeah,
right?
No, we don't have that kind of time. And then we'll come up to Los Angeles and serve you with a subpoena.
I love. Look at Shawarma says, "Hey Zach, the Ask Two Lawyers were a bit offended that you're not going to San Diego. Listen, when there's more demand in San Diego specifically, I will make sure we do a dedicated show in San Diego." Look, Khaleesi Dyer is coming to Los Angeles. Danielle says she's buying her ticket to Brooklyn. I love it. Erica's excited to see all three of us back together. I saw that you guys just had on Josh from the Daily Mail, who was on this show on Monday. Great interview. Lots of good questions. I mean, I feel like it was such a genius move to use the subpoena to dig up the actual lawsuit. So my takeaway from, I guess, both of our combos with him is that it appears that it was likely Stephanie Jones or someone connected to Stephanie Jones that may have given the press this subpoena with the condition that it wouldn't be published. So they wanted, my impression is they wanted the story, the headline to be the subpoena exists, it's real, which a lot of the press did run with, that they had seen the subpoena. But to me, it's so strange that even yesterday in Deadline, Blake Lively's team said she has nothing to hide. And I'm like, well, she has nothing to hide except this subpoena. Like, why can we not see this subpoena? What was your reaction to the initial story about Van Zandt?
Do you want to start? Okay. So we got a call from Josh Boswell last Wednesday morning, and he, one of the conditions of speaking with him is we couldn't divulge what he told us until after his story came out. But when he told us about the Van Zandt filing in New York and that he actually had seen the subpoena, we were obviously very interested and very excited. Stuart and I still have not seen the subpoena. We would like to see the subpoena document itself. But we did ask Josh some questions, and he said he couldn't quote directly from the subpoena. That was his agreement with whatever his source was. But I think he made it pretty clear that it was a New York subpoena. And Stuart asked a very interesting question about, was there a proof of service attached that would show that it was sent out to other parties, such as Wayfair or Baldoni? And his response was he did not see a page like that. That doesn't mean that one didn't exist, but he didn't see it, and he was not shown a page like that. So as far as he knows, there was no proof of service that would have suggested it went out to anybody else.
Which to me is just so strange. So the argument that I've seen from some attorneys online, specifically in regards to the subpoena, is that it's completely standard. And I've always made the argument, there's what's legal and then there's what's ethical. And sometimes those two things don't always align. But when it comes to issuing the subpoena, I was just like shocked that, I mean, one, Van Zandt being the plaintiff here was strange to me because it didn't seem like Van Zandt had any relation to It Ends With Us. So how was Van Zandt damaged in any of this in order for them to file this lawsuit? Number one. But then number two, when it comes to the 10 Jane and John Does that were, referenced in this New York lawsuit, to me, that was even more confusing because we know Justin Baldoni was at least one of the names that we were possibly looking into if we sent the subpoena to Stephanie Jones to obtain Baldoni's text messages. That why are we not naming anybody unless it was to not have to serve those other parties and to kind of keep them anonymous with the intention of trying to, abuse the legal system to obtain these text messages in a more legal, but more seemingly nefarious way. What do you think, Stuart?
The more I look at this, it's not black and white. This is very nuanced. And the more I look at this subpoena, the more I think it's defensible. The more I think that this is something that was not improper. And there's at least a good argument that it was not improper. And that's all lawyers need in court. I know some people don't want to hear that, but right. I do want us to be somewhat objective and look at this. This was very early on in the case, and it was early in the process, and Blake Lively and her team are still trying to identify who are the parties, who are we going after, who has text messages, who has emails. They're allowed to do that. And then something I think that some people haven't looked at here, some lawyers that have been commenting on this case. Look, you're allowed to be very aggressive in your legal tactics as a lawyer. And I think that a lot of people hear or look at this and say, aggressive legal tactics equals unethical lawyers. And I disagree with that statement. I think that I said yesterday that if the same lawyers that are representing Blake Lively were representing Justin Baldoni, the Team Baldoni people would be cheering them on. They'd say Ezra Hudson is the greatest linguist of all time. She's the greatest writer of all time because they're Team Baldoni. These lawyers are all fantastic, and we're all getting an insight into how law is made. Look, there's times where there's aggressive tactics that happen and people have a bad taste in their mouth. But in reality, the lawyers here, they stuck to New York law. They filed a lawsuit. They gave parties notice that were required to get notice. Here they had Doe defendants. They're saying it's early in the case. They didn't know who they were suing. So look, it's defensible. And as Keith said yesterday, if they knew all this stuff and then did it, that may be a different story. But I think everyone's piling on saying this is unethical. No, this is just really aggressive. And it's a really, in my mind, it's a beautiful chess move that I didn't think about using. Now I'm going to think about using the idea of you can't do it in California, but can you sit down and figure out how you can get information within the rules, and it's not unethical, but it is an aggressive legal tactic.
So here's my pushback to you. I wouldn't call it aggressive. I would call it strategic, which isn't a bad thing to do when you're an attorney trying to protect your client, right? Strategic, you want to be strategic. You want to think 3 steps ahead. And to your argument and to your point, I think it really was a brilliant move in the sense that it is like playing chess. However, when you're trying to say that this is about harassment and you're trying to say that this alleged harassment was in retaliation for what happened on the set of It Ends With Us, but yet you hide behind this Van Zandt company that had no part of It Ends With Us, that's where my red flags start to raise, because my question then becomes, what does Van Zandt have to do with any of this? And why hide behind Van Zandt unless you were doing something that was a little more shady? Strategic, but shady.
Well, unless you have a uber famous client that you really don't want to expose to the press right away, and you're not even sure what these subpoenas are going to show. At least this is the argument. And so you're going to use somebody's company, so it's not something that just TMZ or somebody, Zach Peter, asked 2 lawyers. Somebody's going to come across this filing of famous person, and they're going to talk about it. So I think there's an argument on both sides of that. And again, it's so easy to impute all the knowledge we have today to actions that people took months ago. It's very hard to divorce yourself from the knowledge you have right now and go back to September of 2024 and say, what did we understand about the case? Look, there were some bad things that happened. There were some hard feelings that happened. And there was, allegedly Blake Lively tried to take over the movie, and she put herself in a position that nobody asked her to put herself into. And she was being demanding, and she was saying she wasn't going to show up, apparently. And there was the premiere where Baldoni ends up in the basement. I mean, there's all kinds of things going on there, absolutely. But did they know that Jen Abel was involved? Did they know that Stephanie Jones was involved? Did they know that there was a plan to attack back if there's another attack? I don't know that they knew all that in September. They might have, but I'm not sure that we have any facts that establish that's the case.
Well, we do have this call log. Here, I'll pull it up. So we have this call log here, which is referenced in the timeline that shows that at least on August 21st, 2024, there was a call from Leslie Sloan to Melissa Nathan. Now, we don't know what the contents of or what was discussed on this call, but we know that there was at least a call, and Melissa Nathan is alleging that in this call is when Leslie Sloan, Blake Lively's publicist, discloses that she has seen the text messages, and that from there, they're planning on suing Melissa Nathan. Now, to your point about not knowing who was part of it or who wasn't part of it, arguably, wouldn't you assume that Stephanie Jones, Justin Baldoni, and Jennifer Abel and Melissa Nathan, at the bare minimum, were the ones that were a part of it if they were the ones that were working on PR for the film? Like, they were the ones that were working with Baldoni. So if there's going to be a smear campaign, one could very easily assume that they're at least involved, if not more parties, like arguably maybe Steve Sorowitz or Jed Wallace. Okay, those can be some of the John Does that were potentially in this lawsuit that we didn't know about just yet at the beginning. Jed Wallace, I think, is probably the biggest one that would be the mystery until we really dug into the text messages. But at the bare minimum, you knew Justin Baldoni was behind this. And you can come to the conclusion that Jennifer Abel was behind this. Like, unless... why else would you send the subpoena directly to Jones Work PR if you didn't think that Jones Work PR and Stephanie Jones had some sort of involvement, which then tells me that at the very least, you could have referenced them as one of the does.
Yeah, I mean, this is where the deposition of Leslie Sloan is going to be so interesting. And that if I were Friedman, that's one of the first depositions I want to take. And I want to find out, and Stephanie Jones, but I want Leslie Sloan, and I want to know what on that phone call, what was said. And I want to see if Sloan and Jones are going to agree with each other as to what was said, during that phone call. It really just comes down to what did they know and when did they know it? And that's what it comes down to. And in my memory, I was thinking that it had been a text message from Sloan to Joan.
Right. Same.
And then I went back and looked at Exhibit A, and sure enough, it wasn't. It was a phone call, which makes it harder to prove, because obviously if it's in writing in a text, it'd be so much easier to say, aha, there it is. It was a phone call. It was made on August 21st. What was said during that phone call? Jones is going to say one thing. Leslie Sloan's going to say something else. And I do remember, as part of the lawsuit, that Jen Abel had worked out a truce with Leslie Sloan. So they came to an agreement that nobody's going to talk to the press. And it was Stephanie Jones that kind of came in. And according to the complaint that Abel filed, Stephanie Jones, in a ham-handed way, came in and started talking to the press and broke that agreement. Now, Abel didn't know that Leslie Sloan had previously broke that agreement, but still, I mean, the as far as Jennifer Abel was concerned, they had an agreement, and nobody was supposed to be talking to the press. If that truly was an agreement, and then somebody has a feeling that somebody's talking to the press, but they're not sure who to blame for this, you could arguably say that a Doe lawsuit might make some sense. But for me, it crosses the line based on what they knew and when they knew it. If they knew before that subpoena went out that there were, in fact, texts, they knew exactly what those texts said. Maybe they've been shown the text. That would be different for me versus not knowing and trying to figure out what is going on here. Who are we being attacked by, and who do we need to go after? That's a very different. Those are two very different scenarios.
But let's stay focused here on, one person I don't think we're spending enough time on, and that was the onus that was on Jones. Yeah. When Jones received this subpoena, and by the way, we know she received the subpoena. We don't know what was exchanged in a phone call between Melissa Nathan and Sloan. Presumably, Zach, we can assume some things were exchanged there, but we do know for certain that a Doe lawsuit was filed, a subpoena went to Jones, and it looks like she voluntarily complied with it, when what she should have done, in my opinion, would be to file a very simple objection saying, I'm not going to turn this over. These are my former clients. I have confidentiality agreements with them. And to, at a minimum, put Wayfair parties on notice. Hey, I've got this subpoena. People are trying to get your private information. That seems to be the person we should be focusing on here, is why didn't she or her legal team jump up and down and say, we are not going to comply with this subpoena?
Right. And I think my third issue with this lawsuit, because I can hear the argument that Van Zandt was to protect Blake Lively's identity as a public figure. And I get that maybe we don't want to name, even though I think it's weird that we don't name at least Stephanie Jones, who was subpoenaed, and Justin Baldoni, who's the most obvious player here, that to keep them as does is very, I understand that you can have additional does. And we've seen that in the Tom Sandoval, Ariana Maddox, Rachel Leviss revenge porn lawsuit that we're seeing play out right now, or that has been filed, and I believe the trial's beginning this November, where there are additional does that are referenced in that lawsuit saying, we don't know if this, naughty FaceTime video that Ariana Maddox became privy to was shown to other people. We believe that it has, but we don't know who those people are, which to me is a proper example of how to use does in this case, because you believe that, somebody else may have seen the video, but discovery is ultimately going to determine that. But we have to wait to get through that discovery process first. Whereas in this case, there's a blanket coverage of all of the defendants. But the third layer that I think that's the biggest red flag to me is the fact that the actual allegations aren't listed out. Like, it's very vague what happened to Van Zandt in this lawsuit. Like what, and also like if it's harassment, then you're not naming who's being harassed, and you're also not naming who did the alleged harassment. So why not just actually cleanly lay out what the actual issues were and why you're suing? So it's the vagueness of even the allegations that to me was also super suspicious. It's almost like they were looking for something to then want to sue for, because they didn't have anything, is my impression. Do you disagree?
I think you make a good point there. And your last comment there is, the argument's going to be, I don't think they knew what they had, and that's why they had to do this in this vague manner. This was a breach of contract lawsuit that was filed, and there was a couple other causes of action they had in there. But they're going to argue, and I think they're going to convincingly argue to the judge, we at this time didn't know. In fact, that's why we did breach of contract. We thought it was a breach of contract, judge, until we sent this subpoena out, and we did notify somebody of it, and they didn't object. They didn't let their clients know that we were asking for all of this information, and we got it. That's when we realized, we can dismiss this case. Let's go to federal court because of the venue issues, the jurisdiction issues, the personal jurisdiction issues, and that's where we're going to file. They have a story to tell is the issue. And so, Zach, I think Keith and you are probably right. Maybe there was a little bit more knowledge that they had than I'm giving the benefit to. But there's an argument as that for these lawyers to say this was not an abusive process. This was early on in litigation. This is not unlike all litigation where routinely complaints are filed, and then there's a first amended complaint and a second amended complaint because demurs are filed, motions to dismiss are filed, and that's because people learn more about the case as time goes on, and that's precisely, in my mind, what's happened here.
I would like.
Oh, go ahead, Keith.
I'd like to add one more thing to your list, and that is that this subpoena apparently was issued and complied with in New York. This would not have worked in California, because in California, we're required to give what we call consumer's notice, which means you must notify the person whose data you're asking for, even if they're not a party to lawsuit. Doesn't matter what it is. It could be phone records, could be bank records, could be medical records. You simply cannot subpoena a non-party's records without giving them notice. So this would not have worked in California. And my understanding is that phone started in California. That's where it was confiscated from Jennifer Abel. And yet somehow they didn't do it under California subpoena, which they could have done, but they would have had to jump through a few more steps. So that would be the fourth thing that I would think about adding to your list, Zach.
Well, outside of the lawsuit, I think the next red flag then becomes, so if we really didn't know what the lawsuit was about, to your point, Stuart, about like, well, we didn't know if there was harassment or a smear campaign or retaliation, like that's still all kind of big and ambiguous, then why did we immediately loop the New York Times into the conversation so early on? Because we know that they were working on this article in October based off of the metadata, which tells me they kind of knew that there was a direction and an angle that they were going to take this story in if they were already starting to orchestrate it in October. And usually you don't start orchestrating the story on the server prior to actually doing some investigation of the story prior. So the subpoena was served on October 1st. By the end of October, we have the New York Times working on this article that's presumably about harassment, but we don't even see anything that is in reference to Justin Baldoni until December, when the CRD complaint is filed in California, right after they dropped this Van Zandt lawsuit. So my question then becomes, what did the New York Times need to have any involvement in this? And then the next question I think I have is, why was the New York Times then able to run with those text messages or have access to those text messages if the litigation privilege would protect them from reporting on the CRD complaint? But these text messages were not obtained through that CRD complaint's subpoena. They were obtained through the Van Zandt lawsuit. So they have the CRD complaint and Van Zandt have no connection to me.
Yeah, I think that as to the New York Times, Megan Twohey references that she saw a subpoena and then she saw thousands of pages of text. And so I think that the information came after the subpoena was sent to Jones, apparently complied with relatively quickly. We don't know for certain, but it sounds like it was. And by the way, Brian Friedman will get to the bottom of all of this in depositions. He'll figure out the whole timeline of everything because it's going to be important to his case. But the New York Times, they did look at the subpoena. They felt, and they look at subpoenas all the time. It sounds like they believed that this was an authentic subpoena. It was a valid subpoena. The documents that came from it were valid, and they used it to report. And when did they start that article? I don't know. You said the metadata goes back to October. It kind of lines up. September is the lawsuit filed in the Doe lawsuits filed. And at the top of October, the subpoena goes out. If it's complied with quickly, then you would have that information to give to the New York Times so they could take a look at that.
You raised an interesting issue, though, that I hadn't thought about. And this was not in any of the pleadings for obvious reasons, because Friedman's side didn't know about it. But you're talking about subpoenas that were obtained in a lawsuit that was dismissed and didn't go forward. And they're trying to use the fair reporting privilege because of the CRD complaint. But all those documents were subpoenaed in some other lawsuit that was dismissed before the CRD complaint was filed. So it does, in my mind, it makes me wonder, could that be an exception to the fair reporting privilege in that you're talking about documents that, quite frankly, are not part of any filing at that point? Or it certainly wasn't part of the CRD filing that you're reporting on. I haven't thought about it fully. I mean, this is just coming off the top of my head based on what you just said, Zach. But it's an interesting thought and potentially argument.
But there was a filing, though. There was a filing, and the New York Times will argue that they were reporting on that filing.
On a separate filing.
On a separate filing, whether it was dismissed or not. But go ahead, Zach. Sorry about that.
Well, no, the other point that I would then think, because, we also have the Daily Mail that's been looped into this conversation now, and arguably I think people would give more credibility, or at least prior to this case, more credibility to the New York Times over the Daily Mail. And the Daily Mail was very easily able to spot, and in their initial coverage of the subpoena, that there was no official court stamp on the subpoena, and there was seemingly no proof that this was ever filed in accord. And like, there was just so much ambiguity about this subpoena specifically. And it kind of just seems like, my impression, the attorney drafted up a subpoena, gave it to Jones, and she was like, here are the text messages. And it was just way too easy of an exchange for me. But if the Daily Mail, which, arguably could be, considered a little more tabloidy than something as prestigious as the New York Times with Megan Twohey, right? I think Megan Twohey would think of herself a lot more highly, than she would of Josh from the Daily Mail. But I mean, they were able to spot the red flags in that subpoena that the New York Times, who claims they did their due diligence, did not spot or have questions about. And they were given this information seemingly back in October. So they had a couple of months to at least really investigate this, because they said they reviewed thousands of documents. And the same way the Daily Mail has a legal department that could review that subpoena and raise those questions, I would imagine the New York Times has a much stronger legal department that would be able to spot those same red flags, unless they were willing to cut some corners in order to get this story out there.
Yeah. Well, Megan Twohey, it wasn't going to write an article about how Justin Baldoni was a great guy and there was no SH on the set of It Ends With Us. So if they were working on that article before December 21st, when it published, which they clearly were, it had to be in the vein of what it ended up being, you would think.
Yeah, I agree. Okay, I want to get into the Stephanie Jones work of it all, and then I have some questions that people sent in. But first, before we do that, I have a quick message from this week's sponsors. All right, guys, the countdown is on before the new administration exposes the entire pandemic. Most realize a large sum of people's health was negatively impacted by global coercion. Whether severe side effects or experiencing long COVID, check out this natural solution formulated by Dr. Peter McCullough in collaboration with The Wellness Company. And they've just leveled up their original detox formula for $30 less. Introducing the 3-in-1 Ultimate Spike Detox, conveniently constellated into one capsule with 4 times more nattokinase, 500 milligrams of bromelain, and 500 milligrams of turmeric root extract. Nattokinase, an enzyme researched for its anti-clotting effects, may work to break down spike proteins. Combined with bromelain and curcumin, it provides a potent blend for detoxification and cellular support. Crafted with 100% natural ingredients, Ultimate Spike Detox is backed by research offering effective support for your cell's natural repair and recovery. Experience the only formula approved and used by Dr. McCullough, a top freedom-fighting doctor who risked it all. Head to twc.health/nofilter and use code NOFILTER to get 15% off plus free shipping. Again, that's twc.health/nofilter and use code NOFILTER to get 15% off. Get back to that pre-COVID feeling. Are you sick of drinking your calories or waking up hungover? Having some drinks can be fun, but I'm glad that I found an alternative that lets me feel great in the moment and the next morning, and that is these out-of-office gummies from Sol. You may have seen them on my Instagram story, and it's because I'm actually really taking them and really, really loving them. Sometimes you just need a little something in the middle of the afternoon to help you get through the rest of your inbox, or something at the end of the day to help make your evening even more enjoyable. And that's where today's sponsor, Sol, can help. Sol is a wellness brand that believes feeling good should be fun and easy. Sol specializes in delicious hemp-derived THC and CBD products designed to boost your mood and help you unwind. Their best-selling out-of-office gummies were designed to provide a mild, relaxing buzz, boost your mood, and enhance creativity and relaxation. I'm telling you, they're delicious. I also love their drinks. The out-of-office gummies, they come in 4 different strains, so you can find the perfect dose for your vibe. You can choose from a gentle microdose, a perfect buzz, a noticeable high, or a fully lit experience, Litty City all the way. With wellness at the forefront, you can feel good about what you're putting in your body. All of Sol's products are made from organically farmed USA grown hemp and are vegan, gluten-free, and low in sugar. And if you like their gummies, then you've got to try their new out-of-office beverages. It's a refreshing, alcohol-free alternative that's perfect for summer sipping. Like I said, I've tried the gummies, I've tried the bevies, both very delicious. So you're going to want to give them a try. Bring on the good vibes and treat yourself to Sol today. In honor of 420, Sol is running a special on-site sale. Get 30% off your entire order. Just head to getsol.com GETSOUL, getsoul.com, and use code NOFILTER. That's getsoul.com, promo code NOFILTER for 30% off. Go right now. All right, let's get into the Stephanie Jones of it all, because now, as you mentioned, Stuart, you said that she was very quick to turn over those text messages. There was no notice to Justin Baldoni. I would imagine there's some sort of breach of contract there. Well, not only an issue of invasion of privacy, but also a breach of contract, because that was her client. And I would imagine other clients would now be like, I don't want to work with her if she's just so willing to turn over text messages that were my own private text messages.
Yeah, I know Keith has done a really good job of going through the contracts carefully. So why don't you handle that one?
Yeah, and there is a counterclaim that has been filed by Wayfair against Stephanie Jones for breach of contract because of the confidentiality provisions in their contract. And there was a copy of the contract attached, and we looked at those confidentiality provisions, and there was an obligation that Jones Work had to keep client information confidential. So not only would they receive it, they also agreed to keep it confidential unless they were forced to disclose it by court process, which is why they asked for a subpoena. But we've made this point a couple of times now. If we had a phone or any information from a former client and we receive a subpoena, which has happened from time to time, we don't just comply with that subpoena because, number one, we have an obligation not to. And number two, we don't want to be sued by that client. And so what we do is we object to the subpoena. We give the former client notice, hey, somebody's trying to get your information, and we wait for them to take action. And so none of this would have happened if Stephanie Jones wasn't agreeable to say, oh, a subpoena, I'll hand it over. But it does seem odd that she did that and she didn't take more precautions. And I think it would have, if she had taken more precautions, it probably would have stopped that countersuit that ultimately Wayfair has filed now.
Unless her intention was to give up these text messages to help Lively's team.
Yeah, and if somebody's mad and they want to get revenge, and I don't know if that's where Stephanie Jones was, but from the articles and indications, it seems like that very likely that's probably where she was. You can see where somebody might want to do something like that, but I don't know.
Stephanie Jones is, in my mind, being surrounded here because I think that in her deposition, not only are Lively's attorneys likely to be adverse to her because they want to pin down and show that they did everything by the book and getting the information from her and that she voluntarily complied with it, which is damaging to her. Then you're going to have Baldoni and Wayfair saying, hey, you had our information. You were contractually obligated not to turn it over. You didn't even give us the courtesy of, hey, here's a subpoena. There's no privacy rights that Jones owed to people that are subpoenaing her. If she gets a subpoena, she can simply say to Baldoni and Wayfair, hey, I know it ended badly. I know we're not good friends, but here's this subpoena. You guys go and fight it if you want to fight it and take me out of the equation. And she didn't do that. So, if anybody is kind of a villain in this case that everyone's going to be attacking, in my mind and in my opinion, it would be Jones and Jones Work.
Yeah, I think they're the ones that really, it seems like it was these text messages that spearheaded this whole legal saga, which to me is not going to play out too well I just don't imagine how the jury sees any of this and doesn't think that this was in any way shady. Like, it just, to me, it seems like they were intentionally trying to hide behind smoke and mirrors to get, to try to use the legal system so that they did it legally. But to me, there were just so many pieces that, and honestly, I think Stephanie Jones probably had a much bigger piece and even is what pissed off Blake Lively's team by presenting this information this way of like, listen, they created a smear campaign against you. And I think she's the one that planted the seed that ultimately, set the dominoes in motion. And so one thing that you mentioned in your interview with Josh, or maybe it was after, was that you think that that Team Lively is likely going to end up flipping on Stephanie Jones. And so I've predicted at the very beginning that everybody on Team Lively is going to start flipping on each other, including the New York Times. Like, they don't want to be dragged into this. So they're just going to say, hey, this was all Lively's team. Like, they gave us all this information. They gave us all these messages. We didn't know that they were obtained in a, an unethical way, or, arguably it was legally obtained, but, or was it? We're going to have to see, when we dig into the subpoena further. But the fact that we still can't see the subpoena, Lively's team and Baldoni's team, they're all willing to throw their evidence out in the press. And the one thing that is so hidden to the point where it's shown to the press, but you're not allowed to quote it and you're not allowed to publish it. And it's like, that's why when Ezra, Lively's attorney, came out and said that Blake has nothing to hide, I'm like, you hid Van Zandt and you're still hiding this damn subpoena. And they're fighting. And not only that, but they fought for their attorney's eyes only protections. They are fighting to not have to move into discovery because they filed their motions to dismiss and they filed their motions to stay discovery. So they're fighting very hard to conceal this subpoena, in my opinion. So we have nothing to hide, to me, is not an accurate statement.
Right. And I think it's only natural that Ezra Hudson and the Lively team has to turn on Stephanie Jones, because they're going to say, look, Stephanie said that she had this information. She told us what she had, it's probably going to be the story. But she wanted a subpoena. And so we went and got a subpoena. I mean, she could have just handed it over without a subpoena, but she wanted a subpoena. And so we're not the bad people. It's her. She's the one who had the obligation to keep it confidential. We don't have any obligation to keep it confidential. So I could see where that would be the Lively team argument and they probably will have to turn on Jones. But no matter what happened and how it happened, I think that the upshot of all of this is that they handed a gift to Brian Friedman. Because now, standing in Brian Friedman's shoes, you're going to say abuse of process. And I'm going to put that in every motion I file. Every one of my filings, I'm going to say abuse of process. Even if it has nothing to do with the subpoena, I'm going to say abuse of process.
And Zach, I want to point out this is significant, what Keith just said. Brian Friedman and his team were a bit on the ropes with this 47.1. And we have not been talking about 47.1 for the last week. We've been talking about this quote unquote sham subpoena, sham lawsuit, the Doe lawsuit. The script has flipped once again in this litigation. And now I agree with Keith. If I'm Brian Friedman, I'm going to squeeze every drop out of the arguments that I can make that this was just sham. It was an abuse of process. There should be sanctions. We should have firms disqualified. I'm not saying the court's going to do any of those things. I'm just saying if I'm Brian Friedman, that's the story, that's the script, and that's what we're going to focus on over the next couple months.
Well, and now it does kind of make a bit more sense as to why she was fighting for attorney's eyes only protections when it comes to third party privacy and when it comes to, what was it, business dealings that weren't directly related to It Ends With Us, because essentially that would have protected Van Zandt, because Van Zandt has nothing to do with It Ends With Us. It had nothing to do with the film. It wasn't contracted in any way. We saw Blakel Inc. was contracted. We saw Ryan Reynolds Marketing Company was contracted. It was interesting. We even saw Blake Brown came out, sent a letter to the judge saying, hey, judge, you granted her an attorney's eyes only protection for third-party privacy. We're just letting you know in advance that we are going to exercise our third-party privacy. So don't plan on digging over here, which to me was another big red flag. I'm like, if you're coming out and saying, hey, judge, don't look at me over here, then immediately my eyes then go to the person raising their hand saying, I don't want to participate.
Right. Yeah, exactly. And they wanted the ability. Oh, sorry.
Go ahead.
They wanted the ability to unilaterally mark things as attorney eyes only. That's what the Lively team wanted. And yeah, maybe now you're starting to see why.
Yeah, I mean, and if Stephanie Jones really was the one that put the subpoena out into the press to get that headline out there, she really fumbled the ball and really screwed Team Lively here, because had the Daily Mail not dug into the Van Zandt piece, because Van Zandt's clearly on the subpoena, which probably tells me that's why they didn't want the subpoena published, because they knew the internet sleuths would then dig into Van Zandt. But not only that, but I mean, not even being able to quote it, I think would also kind of prevent you from being able to say anything related to Van Zandt too, no?
Well, yeah. And who benefits most from this subpoena being disclosed to the press, but then not being disclosed to everybody else? I don't know for certain, and you already mentioned it, but it seems like it probably came from Jones' camp, because they want to show that they didn't voluntarily give this information over. And that better be true, Zach, because if they did voluntarily give information over and then orchestrated a subpoena idea so they could cover up their tracks, and I'm not saying they did that, I'm just saying if that did happen, that's going to come out in deposition. You're not, the cover up is always worse than the crime. And so, what was disclosed is going to be determined here. And then when did the subpoena go out? So, and it could have been disclosed after the subpoena, but there's a lot of questions and timeline that Brian Friedman and his team will get to the bottom of in taking all these depositions.
Right. So we got an updated timeline this morning that lets us know what's happening next when it comes to discovery. So do you know when we're supposed to hear about the motions to dismiss? Do we have a deadline on when the judge is going to give us an answer on that?
So under federal court, there's no set deadline. Once the replies are filed, everything's under submission. And now it's just a matter of he can either set oral arguments if he wants to, or he can rule just on what was filed. I would imagine that we'll hear within the next week or two, but there's no set deadline for that.
Okay. So we did get an updated timeline when it comes to discovery. So all fact discovery is currently due by August 14th. And then we have the deposition and discovery deadlines that have now been extended to October 15th. So can you explain what the difference in these two deadlines are? What should we expect by August and what should we expect by October? Because I saw Daily Mail put out an article this week that says that Taylor Swift and Hugh Jackman are likely going to be deposed any day now. They said that it could happen as soon as this week.
Yeah. And I would think the fact that the discovery deadlines are for the third-party subpoenas and, all the subpoena work that you have to do to find and uncover facts, the depositions are actual depositions of both parties and non-parties. So they have until October 15th to depose everybody, including Taylor Swift and Hugh Jackman. You can imagine how difficult it is to coordinate depositions in this case because you have to work with all the attorney schedules. The parties have a right to be at the depositions if they want to. You have to coordinate with their schedules and then the witness schedule. So, and then like Taylor Swift, her attorney is going to be at her deposition. So it takes a lot of time to coordinate all these dates. And then the discovery deadline would just probably be the discovery in between the parties. So there's certain discovery that the parties have to exchange. So all of that will be done by October, but then the fact discovery deadline, all the subpoena work will be done by August. And it just gives them a couple months after all the subpoena work is done to wrap up any depositions that they might have for witnesses.
So then what can we expect to get in this timeline between now and August 14th? Is there anything that will I'm assuming we won't be seeing these depositions filed over the summer, but when it comes to the subpoenas that are going to be issued to both parties and the evidence that gets turned over, is that any of that going to be filed publicly in court for us to have access to?
It possibly could be. If you remember, there were some requests to get an extension on discovery, and there was some information about how much discovery was propounded. But for the most part, the answer is no. We're not going to be able to see how the sausage is made here unless somebody leaks it. That could happen. And then, of course, every little piece that comes out, we'll all be analyzing and looking at and trying to, figure out where's this case headed from here. The one thing I noticed on that list is they didn't continue out the expert depositions, which expert depositions come after the party depositions or third party depositions. And so I'm not even sure, who they're identifying each side as experts. We'll know that at some point in time. And the experts are going to be used for the Rule 56 motions for summary judgment that will come after the motions to dismiss. So right now we're at the motions to dismiss phase. Discovery's ongoing. They're under these tight deadlines to get done. Federal court moves very quickly. And as soon as the motions to dismiss are done, once the facts are determined from the discovery process, from the deposition process, and then you have experts who have opined on this as well, you're going to see motions for summary judgment filed. And those are just motions to dismiss on steroids, because now it's no longer just the four corners of the document and looking at the legal analysis and assuming that everything in the complaints are true as pleaded. Now we get into the facts of the case that we've gotten from the discovery process, and we argue that the other side doesn't have any facts to dispute our facts, and therefore we should just win. And we're asking the Judge Lyman once again to dismiss the other side's case based on a Rule 56 motion for summary judgment. That hasn't even started yet, Zach, but that will be the next round of pleading. And by the way, we'll get a lot more information there because there'll be exhibits, there'll be references to the evidence that both sides are going to be pointing to. So if we're wanting to know what evidence people are going to be looking at, that's where we'll find it, the Rule 56 motions for summary judgment.
Okay, let's get into some questions because we have a few. Jim wants to know, Stuart, what about the fact that the Van Zandt lawsuit says that there was a contractual obligation? Explain the contract that exists between Van Zandt and anyone related. I'm assuming the 10 Doe defendants.
Again, this was a breach of contract suit. And what Lively's team is going to argue is, look, we thought we had this agreement We know there were problems on the set. We needed to get this movie out. We needed to get it premiered. We wanted people to go watch it. We wanted it to be a successful project. So we all agreed to get along, so that we could get that done. And then we heard through the grapevine that Justin Baldoni was going to be coming after us with a quote unquote smear campaign. And so we had to arm ourselves and be prepared for it. And we got insight that somebody may have some text messages that would disclose this quote unquote smear campaign that was being set up. So we did what good lawyers did. We filed a suit the best we could, because it sounds like it's a breach of contract claim, breach of good faith and fair dealing. And we went forward and got it. So I think this was, just a very general, vague lawsuit based upon the timing, because it was early on and not all the facts were known. And they're, getting a subpoena and they're figuring out what's going on.
Yeah, just Ricardo says they tried to be the subpoena-Oprah.
Nice play on words.
Vipan says, quotes, concerns, refers, relates, and applies to any and all electronic records, data, documented communications in your possession, custody, or control collected from a cellular telephone containing the requested information. I'm assuming that's the quote from the subpoena that they issued to Jones' work, which again is very broad. They're saying, just give us everything you got. But again, give us everything you got of what? How is Stephanie Jones supposed to determine? Thank you, Vi. How is Stephanie Jones supposed to determine what information to turn over if it was so broad to say all electronic records, data, documents, and communications in your possession? In your possession relating to what? In your possession relating to who? None of that was outlined in the lawsuit, and I assume none of that was outlined in the subpoena, which is why they didn't want it quoted.
It might have been outlined in the subpoena in a different section. That's why we're so desperate to want to see the subpoena. But focusing back on Stephanie Jones and Jones Works again, okay, you got that broad of a subpoena. Did you give them your phone, or did you only give them Jennifer Abel's phone? And so once again, I think the bad actor in all of this, potentially, based on what we're seeing, is probably Jones Works.
Well, because that's the thing. Good. That's a really good point, because we didn't see any of Stephanie Jones' text messages in the New York Times or in the CRD complaint. So why didn't we see any of Stephanie Jones' info? And again, if they're, asking for all electronic records, all data, all documents, all communications, I want Stephanie Jones's emails. I want Stephanie Jones's text messages. I want to know how involved she was in all of this. And if she was so deeply involved, which I would imagine all of that correspondence would prove, why wasn't she named in the CRD complaint? Why wasn't she referenced or brought up more, deeply in the New York Times article? The New York Times reviewed thousands of documents. Of these thousands of documents, why are we all conveniently leaving Stephanie Jones out of the equation if the subpoena should have been able to bring in records that shows that she was complicit in this? Work on your business says, are judges looking at the news regarding their cases?
Well, they're going to tell you they're not. I'm sorry, you were going to answer that, Zach. Go ahead.
No, you guys would know better than I do. I don't work with judges.
I mean, no, judges would never admit to doing such a thing. But look, this is a public case, and I'd be shocked if Judge Lyman isn't at least keeping his finger on the pulse of what's happening in the court of public opinion. And now, he would not come out and say that publicly, nor should he. Yeah. And by the way, jurors do the same thing. There's an instruction we give to juries, and the judge reads it to them 3 or 4 times and really tells them they cannot be on their devices and looking at any news. They just literally have to stay off their devices. And I will say jurors do tend to break this one, in my experience. They won't come out publicly and say it, but they just can't resist it. They've got to jump on and see what's going on. I think there are some jurors that don't, but I think it's such an irresistible force to look on your phone to see what happened in the news that day on the Amber Heard case. It's just too hard.
But not only that, but like you said, anybody that can open their phone and access social media is likely going to see something. It's a big story. True. OJ Simpson, Amber Heard, like those trials, like you're going to see something. But not only that, but if you're at the supermarket, if you're at CVS, you're going to see magazines, and magazines are going to have headlines, and they're going to have people's faces on them. Like it's completely unavoidable. But I would agree. I don't think they're actually admitting it. Vi clarifies that's a direct quote from the subpoena off of Deadline. Naming a specific phone indicates a breach in confidentiality. No, Stephanie Jones letting Blake's team know which phone contained what she wanted. Were they specific in terms of which phone though?
Not in the quote that you showed us, and I don't think we know the answer to that. I'd have to look at the subpoena. But my question for Stephanie Jones would be, did you fully comply with the subpoena? Because their statement is, oh, we had no choice. It was a subpoena. We had to comply with it. Did you just partially comply or did you fully comply? And that would be an interesting question for her.
Was the phone that was downloaded for Jen Abel, were there things taken out of that prior to it being produced? So those we don't know that, but that's.
And if you didn't fully comply with that subpoena, then you're not staying true to your statement of we had no choice, we had to comply.
True.
Yeah, sorry, that's a crock of shit. If you're like, I'm going to apply with the subpoena, but only give these text messages. I'm going to protect my privacy, but my clients, nah. Here you go.
Right.
That's where I draw the line. Jane of All Trades says, even if the subpoena was legal, it was filed in October. Leslie Sloan said that she saw the text messages in August. Jones violated her confidentiality agreement at minimum. Or maybe I don't know. According to Melissa Nathan, Sloan said that Sloan said that she saw the text messages. So text messages
maybe. I mean, it's a she said, right? And so that's why their depositions will be important, and their testimony trial will be important as well. Who's more credible?
Yeah. A Numbers Girl says, hi from Oak Island, North Carolina. I absolutely love your coverage of this. I think I have found my people right here. Awesome. CJ Ward says, if you have a questionable subpoena that obtained text messages that were supposedly altered in Blake Lively's complaint, at what point does the court call out ethical behavior? You three are amazing. Thank you. Well, I think the argument that we've gone back and forth with at the top of the show was it ethical or was it not ethical? It was technically legal.
Yeah, and what you put in the complaint isn't relevant. That's just your allegations. What really matters is, what did you know and when did you know it? And then how are you trying to use this information? And that's something that I think ultimately the parties will bring before the judge and he'll have to decide.
This is a good question from Tiffany. Tiffany asks, how many hours are depositions allowed and can you split the time up between 2 deposition days?
The hours are 7 hours. So you get 7 hours of deposition time per witness. And it's deposition time. It doesn't include breaks and things like that. You can split it up. So you can do like 3.5 and 3.5 over a couple of days if the parties agree. And then you can ask the court for additional time. So some witnesses are going to need more than 7 hours. And the parties can either stipulate to that or you can ask the judge for additional time.
So they can have Blake Lively in her deposition for 7 hours.
It's actually
questioning her.
It's actually not that long because it used to be there wasn't a 7-hour rule. And so people panicked when we got the 7-hour rule. Because if you think about it, if there's 4 lawyers in the room that need to ask questions, they have to divide that time up amongst themselves. And they already don't like each other to begin with. So trying to get them to agree on, well, I've got another 15 minutes. Well, you're over your time. But 7 hours goes by like this in a deposition.
Yeah. Okay, here's a good question too. Christine says, is it legal if Stephanie Jones did not own the phone number at the time of the subpoena, which she did not? So this is where it gets a little murky, right? Because the phone was technically owned by Jones Work PR. It was a company phone. However, Jennifer Abel was using her personal number. And I've had this done when I've, had a job where I was offered a company phone, but I wanted to at least keep my number. That way I didn't have 2 numbers and 2 phones. I was like, I'll keep my own personal number. I can use that on my work phone, but I didn't want an additional phone. Is like, what are the laws around that?
Yeah, the device, it does belong to the company. And I think any of the text messages on there that Jennifer Abel was sending in furtherance of her employment, which arguably she was in these text messages with Melissa Nathan, I think that's fair game that it belongs to the company. I'm sure there's all sorts of other information on that phone that did not belong to the company that would be private to Jennifer Abel, such as her banking information, because she said she couldn't even get into her bank accounts after the phone was confiscated. So there's sorts of problems with that. As far as these texts, I think these text messages were in her line of employment with Jones Work. I think Jones Work did own the device and they had the right to those text messages. But then they did have to comply with their confidentiality agreement with Wayfair, which, we'll see how that pans out, but they have been sued on that.
Jenny asked, did we answer this? How can Van Zandt validly obtain information for breach of contract when Van Zandt did not have any contact with anyone?
It's just allegations. So in a lawsuit, all you have to do is make allegations. And so I could file a lawsuit today alleging that I have a breach of contract with Zach Peter. And it does, we're not supposed to file things that aren't true, but if there's some, way that I could say, well, I think Zach and I had a contract, I can file a lawsuit on that. They're just allegations. So it doesn't have to be 100% proven to be true before you file a lawsuit.
Yeah. Cindy says, I need to get Cassidy O'Connell on the podcast. A lot of people have been referencing Cassidy O'Connell.
Yeah.
I haven't seen her video yet, though. I'll have to watch it.
I don't know. I heard through the grapevine that, and I don't know if it was Cassidy. I think it was Cassidy that the report was that Cassidy said that asked two lawyers were afraid of California Civil Code 47.1. But if you do have her on, I'd like you to ask her, does she really think we're afraid of California Civil Code 47.1? I think that'd be interesting.
Well, let me ask you, are you afraid?
No, we're not afraid of it. And we have talked about it a lot. And so did Brian Friedman in his opposition to the 12B6 filing by Blake that was done so masterfully. And that's because it is a draconian law. It is a law that's going to hammer his clients. And it's something I'm not sure that they fully appreciated when they filed the defamation claim in response to the SH claim that Blake had filed against them, because it was a relatively new law. It hasn't been used a lot. In fact, there's not even any appellate cases in California that have come out on that particular law. But because it does impose significant damages to a losing party, it's something you have to consider and think about. Now, once the client says, I'm willing to take on that exposure, then the lawyer can say, hey, let's go to trial. Let's litigate all day long. But it is a big deal. And again, I really do think that this Van Zandt thing has quieted some of that down so that Brian Friedman can now flip the script, because he was tired of that 47.1 stuff. He's still got to get through it, which he will, but no, we're not afraid of it.
I mean, listen, if I will say, going into the discovery phase, I know you said that we likely won't see a ton of stuff unless it gets leaked. I pray that if somebody does leak something, it comes from Stephanie Jones, because she is so messy with how she does these things, and it always backfires in some way. So I hope Stephanie Jones does try to leak, or her camp does try to leak things into the press, because it always just blows up in the way she doesn't intend for it to. And it just is so yummy, to quote Blake Lively. Shanna says, if Justin Baldoni wins, how long does Blake Lively have to pay the $4 million? What if she doesn't pay?
Yeah, there's a whole section of the law just about collections on judgments. And so when you get a judgment, the other side doesn't automatically have to pay it, but there's mechanisms that a plaintiff can use to force the payment, such as garnishing wages, doing debtor exams in court, finding assets and bank accounts and taking that. So there's a whole system, and judgments also run what we call statutory interest. So like in California, if you get a judgment, it runs 10% interest per year. So you can imagine if they do get a $400 million judgment, the interest on that would be $40 million a year. So there's an incentive that's built in as an incentive to make people want to pay these judgments. But yeah, that's a whole separate area of the law, and there's lawyers who just specialize in collections.
Now, to fight 47.1, is it possible that this whole subpoena Van Zandt lawsuit, this whole, thing, this whole orchestrated lawsuit, could that be used to prove malice in this case and prove that they were, deliberately? Because I mean, not only we have Van Zandt, we have the subpoena, we have the leak to the New York Times, we have the CRD complaint in California. I mean, and the subpoena, as we've mentioned before, was issued in New York, but it was, given to Jones' work, which is in California, which is where the phone was. And I don't know how the phone would just magically make its way to New York. Could this possibly prove malice for Baldoni's team?
Yeah, the problem with malice is you have to think about what is malice in this context. Baldoni's suing Lively for defamation.
Right.
As part of that, he has to prove malice. What that means in the defamation context is that at the time that Lively made whatever statement she's being sued for, she either knew it to be false or she had a reckless disregard for the truth of that statement. So a lot of the statements stem from like the 17 points in the SH claims, and that was done way before the subpoena stuff. So I have a hard time connecting the subpoena with malice in terms of how it has to be proven for purposes of defamation. I think some people are confusing malice with the idea of, well, if I prove that, Lively's a bad person, I win because she's being malicious. it's not just general malice, it's malice in terms of making a statement. And so that's the distinction there. And that's why I don't think it's going to have a big impact on malice. The subpoena, I don't think the subpoena issue is going to have a big impact on the proving of malice for purposes of defamation. I do want to say one thing about Cassidy O'Connell, because I have watched her videos, and to her credit, she did say in her video as well that she really appreciates the open discussion that all of the content creators are creating around this topic, and the fact that everybody has the ability to bring forward their own views and ideas and thoughts on this issue.
I think that's what makes this case so unique, right? Because if we look back to other big celebrity I mean, the last really big one that like made such headlines like this, I mean, I would say would be OJ, because he was very popular, but the difference, or it would Depp v. Heard, but I feel like Depp v. Heard was kind of at the beginning of podcast YouTuber live stream coverage that we're now seeing with new media. But like back in the OJ days, you really just kind of what you saw in the news, was what you saw in the news, and that, you know, determined what you heard about the case. But I feel like now in this era of 2024, 2025, you have so many people that are able to analyze things so differently that like you have all the internet sleuths, all the mommy and daddy sleuths that are kind of picking all this apart and looking at it from different angles that, you know, I watch your videos and I'm like, wow, that's an interesting point that I never considered before. And I watch other creators and it's kind of the same thing. And I like that we at least have this, but I also feel like it's helping the legal teams kind of, you know, whoever's whatever interns are monitoring the chatter online, it's helping them kind of creatively look at things. Whereas maybe before you had a team of 5, 6, 7, 8, 9, 10 people with, you know, interns and paralegals and attorneys. Now you have the entire internet that's coming together on Reddit and on YouTube that's putting together these theories.
Yeah, very true.
I think is powerful. Well, I guess we'll see how powerful as these cases continue. Vice says it appears Stephanie Jones fired Jennifer Abel before her last day to obtain her phone before Jennifer Abel could strip its info. Is there any employment laws broken if unemployed as part of a conspiracy? Stephanie Jones working with Blake Lively. Well, my understanding is Jennifer Abel was planning on leaving the company, and that's when Stephanie Jones fired her, if I'm not mistaken.
Yeah, she gave 6 weeks notice, and then I think Stephanie Jones, you know, obviously ended it before the 6 weeks, which is not uncommon. I mean, that happens all the time in employment situations. I think the bigger problem is just the whole way that she did it, the way that she confronted Jen Abel in a conference room. She had a security guard standing outside, which made Jennifer Abel feel like she couldn't leave. You know, she had an attorney there and said, here, sign these forms. And, you know, you're not allowed to have another attorney review them, which is a big problem under California's employment laws. So just the whole way that it went down was not ideal, I think.
Here's an interesting one from Ariana Boykins. She says, do you think Blake Lively could use Stephanie Jones as a way out of this lawsuit, that Stephanie Jones gave them false or misleading info that caused this?
What do you think of that one, Stuart?
I mean, it's possible. I mean, you know, I don't think she's a big fish. I don't know how much her company is worth. Her husband has. Obviously, it looks like he has some resources. I don't know. I haven't looked into him. But yeah, I think that I don't think Justin Baldoni is going to be saying, yeah, let's go after Stephanie Jones here. He wants to go after Blake Lively and he wants to go after Ryan Reynolds. And I think that's going to be the focus of the case. So yeah, if you were Blake Lively's lawyers, you would definitely try to pin it on somebody else. And by the way, this is going to be a quite confusing jury trial. And when juries are confused, they tend to not award damages. They tend to just be so confused by the whole thing. So really the job of whoever wants something from this jury, a finding in their favor, it's going to have to be clear. It can't be muddy. It's got to have to be clean. And you're going to have to go through those jury instructions with them at the end and closing. And you're going to have to literally put the verdict form out in front of them if the federal court will allow it, and walk through it and say, here's where you say yes. Here's where you say no. Here's where you say yes. Because sometimes juries want to find in your favor, but they get back in the deliberation room and they're just so confused by the whole process. So defense lawyers for years have slung as much mud as they can against the wall, proverbial wall, to confuse the issues, because they know a confused jury generally won't make big damages.
Yeah. It's going to be interesting to see how this all plays out. What are your odds on this going to trial versus a settlement over the summer?
Well, settlements are always possible. I think that in the beginning, we were pretty certain that the case was going to settle. Now, with all of the motions that we've seen, especially Ryan Reynolds' motion to dismiss, our thoughts on settlement is it may not be as likely to settle as we thought. But there's always a path to settlement. No matter what you do, there's always a path to settlement. So there is still a chance that this could settle over the summer, but it looks like everybody's gearing up for a long, lengthy war here.
Yeah. Leanne, who has great coverage on X. She does different feeds or different threads where she breaks down a lot of the stuff. She's an attorney herself. She says, can we ask how lawyers would have known it was specifically a mobile phone? I'm assuming in reference to the subpoena.
Yeah, I don't know. Do you have any idea?
I'm making an assumption it's a mobile phone because it was a number that needed to be ported, and Jen Abel went to the Verizon store afterward. She was waiting for the number to be ported so she could buy a new phone. So it seemed to me that it would be a mobile phone, and it ended up in New York apparently because it was subject to a subpoena in New York through this Doe lawsuit. As Keith pointed out, if it had stayed in California and you were subpoenaing it in California, you would have had to do consumer notice, and that would have given notice to Justin Baldoni and Wayfair, et cetera.
Yeah. But again, how would the phone make its way to New York? And why would the phone make its way to New York? That's the bigger question is it's like, if the phone was in California, what's the need to send it to New York, if not to help set this whole legal saga in motion?
Right.
I don't know. Thank you guys for coming on the show today. Always a delight chatting with you. Your podcast, your YouTube channel is Ask Two Lawyers. Everybody needs to go and subscribe. You just had on Josh, senior reporter from the Daily Mail, who was great, answered a lot of good questions on your show. So everyone needs to go and support that. You've had Kirsty Flaw, you've had Dave Neal, you've had a lot of great guests on your show. So good coverage that you guys have been doing. How often are you guys streaming this case?
We try to do at least 1 or 2 a week. I think last week we got in 3. I think this week we'll be lucky to do 1 just because we do have our day jobs. And so it kind of gets in the way. But we're trying to come out at least once or twice a week. And of course, anytime there's anything major that happens, we like to do an update.
Awesome. Keith, Stuart, thank you again for coming on the show. Always appreciate you guys. Always a delight. You'll have to come on again soon.
Thanks, Zach.
Thanks, guys. All right, just a reminder, guys, as we wrap up, tickets are on sale now for the No Filter Zactivated Tour, which kicks off this July. We start things off July 11th in Dallas, Texas, and then we wrap it up in Los Angeles August 10th. So get your tickets now. Today's the last day. Wednesday, April 23rd is the final day to lock in early bird pricing. So if you want a discount on tickets, you got to get your tickets in today before prices go up. We're coming to Dallas, Phoenix, Philadelphia, Toronto, Brooklyn, Chicago, Seattle, Los Angeles. And like I said, I'm praying Stephanie Jones leaks some more stuff from the discovery process over the summer so we can break it down live on stage. All right, guys, get your tickets at nofilterlive.com. Love you, appreciate you. Give me a follow, Just Plain Zach. Follow the podcast at No Filter with Zach, and be sure to follow and subscribe Ask Two Lawyers. Keith Davidson, Stuart Albertson, always great guests. All right, guys, I will bounce and I will talk to you tomorrow. Have a good one. Bye.